I am really happy today to be talking to Jennifer Huddleston, who is the Director of Technology and Innovation Policy at the American Action Forum. And her research focuses on the intersection of emerging technology and law. And since the Institute for Regulatory Law and Economics has a primary focus on improving regulatory decision-making in the face of dynamic and changing technologies, we have, I think, a lot to discuss. And in particular, we are going to discuss today a law review article that Jennifer wrote with Ryan Hageman and Adam Thier in 2018 called Soft Law for Hard Problems, The Governance of Emerging Technologies in an Uncertain Future, which was published in the Colorado Technology Law Journal. So Jennifer, thanks for agreeing to talk with me today.
Thanks for having me, Lynn.
The title of the article is a good place to start, Soft Law for Hard Problems. So what do you mean by soft law, and what are some of the hard problems that you think we should use soft law to grapple with from a regulatory perspective?
Soft law is often easiest to define by what it's not rather than by what it is, which basically what it's not is what we would call hard law. Hard law, it refers to the formal regulation that we often see in the form of legislation or rulemaking from agencies at either a federal, state, or local level. But it can also refer to any kind of regulatory actions that have that real formality associated with them, that are unchanging and static, and a very top-down approach to regulating technologies or an industry. Soft law, in contrast, is more amorphous. It's more flexible. It's various things that an agency may do that certainly have some impact, some regulatory authority behind them, but lack that perhaps real enforcement authority or lack some sort of real restriction that you would typically see with hard law and legislation. As a result, they're much more changeable and adaptable when facing an ever-changing situation. So some examples might be multi-stakeholder working groups where you would see an agency or a commission convene to meet with civil society and innovators or industry leaders and regulators to come up with a set of best practices, for example, for addressing a problem. It can also be guidance documents in some ways, or it can be official statements that are made regarding a new innovation that, again, are not necessarily a formal notice of rulemaking the way we would see with hard law, but are more of a, this is how the agency is thinking about approaching this issue. We've seen a lot of workshops come on and go on as well. At the more formal end, this can also involve things like sandboxing, where you have a more formal dynamic between an innovative product and a regulator to perhaps remove some of the restrictions that may be governing that product, but not necessarily to do so in a fully permanent way. The reason we've seen this emerge is to get to the second part of your question of kind of where does this come from, or what does the title mean, is that in many industries, we see innovation has had a hugely positive impact, but that the dynamics of this innovation mean that regulation may struggle to keep up, that you have what has been called the pacing problem emerge, where technology moves faster than regulation. At times, this can be a benefit to certain technologies that are able to get on the market more quickly, in part because they don't find themselves burdened by regulation. But in other industries, this can be more of a true problem because regulation isn't able to keep up and adapt, and new innovations that could improve things find themselves burdened by outdated regulations. So in that way, soft law has this more adaptive option that can help solve this problem in some ways.
So soft law is a way to an alternative way to think about implementing a regulatory framework, but to deal with kind of the pacing mismatch between innovation and these, kind of legal rules that, as a non-lawyer, I tend to think of as, you have these legal processes that put in place a set of laws, and then that's meant to give you some regulatory certainty, right? So that's an interesting question. How then do you think about that trade-off between regulatory certainty and the flexibility and adaptability to changes?
Well, in some ways, this is how soft law is very advantageous at times to the no regulation at all approach. Of in certain industries, innovators or investors need that at least some degree of certainty that the regulator is not going to come in and shut down a new idea immediately, that soft law can provide that here is our guidance on autonomous vehicles, or here is our guidance on a new form of energy technology or a new financial product that is not necessarily the end rule or a formal rule, but we're taking questions on this, we're having thoughts on this, where at least you know that the view of the regulator is not that this is going to be declared completely unallowed. On the other hand, we have the problem with too much certainty in the form of formal hard law can prevent new innovations, because there's this sense that it takes a lot longer to challenge, it takes a lot longer to change a rule. Even if you go through the courts, the cost and time to overturn a rule could be quite cumbersome. So soft law can kind of be in that in between that provides some degree of certainty in areas where that is needed, while still having that adaptive approach that if regulators get it wrong, which happens, that knowledge problem, that need for regulatory humility, they're able to adapt and change as they either see new problems arise or perhaps even see things that they didn't think were problems, or perhaps see things that they thought might be problems not arise. They're able to change that soft law more quickly and more easily than they would with a formal hard law.
And in thinking about applying the soft law framework to an industry like electricity distribution, where the guts of the physical infrastructure and the guts of the existing business model, it's been regulated this way for 110 years, is the physical distribution network. And so this is electricity is not like taxis, say. It's not like you can just have Uber kind of come in and do their thing, and then after a while people are so attracted to Uber that they are just like, wait a minute, why do we have all of these onerous regulations? The distribution of electricity is very different. And so, and the regulatory landscape is very much one that is very formal, right? Very legalistic. And so I think there are a couple of different ways that soft law can be useful. And I'm interested in your thoughts on that. In particular, starting with the idea that, the public utility regulators are really familiar with stakeholder processes, right? There's always stakeholders intervening in their formal regulatory processes. So the idea of a multi-stakeholder working group is not that much of a stretch. But it's a different way of thinking about stakeholders, because in a traditional public utility framework, the landscape in which they interact is usually through a rate case, and so it's adversarial. So how would you compare and contrast what you're thinking about with soft law with something, that more adversarial process that they're used to?
Well, I will start by fully admitting that I am not an energy policy or law expert at all. So I apologize to anyone listening I'm taking this from the kind of 10,000 foot level of how we've seen this play out more generally in the regulatory state, and in some areas that I've written more about, such as transportation innovation, where it has been very successful, both on a federal level and on a state and local level, in working with different companies. And that is also a relatively heavily regulated industry when it comes to things like autonomous vehicles. I think that there's a difference in a multi-stakeholder working group that might be utilized, and a more traditional intervener process or a traditional notice for comment process, because you could argue that there's always accepted input from experts, from innovators in hard law rulemaking processes under the APA, or in more traditional adversarial processes like you mentioned. But the difference is that you are opening up these conversations to innovators at the beginning instead of after a rule has already been put on the table, which signifies an element of regulatory humility on the part of the regulators, a awareness that perhaps the regulators don't know everything there is to know about the innovation or about what the next steps might be, an openness to hearing ideas from different stakeholders, not just from necessarily the innovators and the companies themselves, but also from civil society groups who may have opinions, or from people that may be looking at both harms and benefits in different ways of these next steps. So we've seen this a lot with workshops around different products, particularly relating to data. We've seen it also around best practice, to develop best practices on different products. So I think that's one way that it is different, is that you are welcoming innovators at the start rather than handing them an almost finished product. Another easy way I think that regulators might be able to signal this regulatory humility and openness to innovation or to conversations around some of these ideas and implementing soft law is what we've seen happen in autonomous vehicles laws at a state level sometimes, where it'll be, this is our framework for petitioning for a license or for admission to the sandbox. But there will be this kind of last line in there of, if it does not meet this framework, we are open to new ideas as well, or you may still submit a petition for consideration or something along those lines, that this is kind of our general what we're looking for framework, but we recognize that we might not be able to predict every way this innovation is going to go. Pennsylvania has really embraced this soft law framework for autonomous vehicles by having this kind of approach that says, if it's not covered under our current guidance, that doesn't mean you can't discuss that it wouldn't be covered in the future with us.
Yeah, and I know Pittsburgh has a lot of experimentation going on with autonomous vehicles, which is really cool. What about, I think, in the in the electric utility industry and in general, there's a lot of use of pilot projects. And so I think the connection of the idea of pilot projects to this sandboxing, but thinking about thinking about the regulatory guidance more broadly and in the way that you just described is something that is worth considering. One other challenge that happens is, we've got 50 states plus the District of Columbia. So 51 different public utilities commissions, 51 different approaches, and some PUCs have latitude to have a lot of technical workshops and to do things that essentially are promulgating policy. Other commissions see their role as basically implementing policy that the legislature defines. So and that I think is a tougher and trickier environment in which to think about soft law. So if you're in that kind of environment where you think, I'm just promulgating what the legislature has determined the policy to be, what are some examples of how regulators could use soft law in that context?
I think drawing on kind of the last example I gave of, if there are of signaling either formally or informally that if there are new ideas that are not covered by the existing regulation, that you're open to considering those ideas in some form, not necessarily even a formal sandbox or licensure program, but working with local innovators, working with other departments to kind of ask questions around what the future might look like, and not automatically assume that you're going to be able to dictate or describe it as it is right now. I think when we're talking about pilot programs as well as sandboxes, that they're great examples in a lot of ways. But one thing regulators also need to be asking themselves is, what is their goal and what is the outcome after these programs? We want to be very cautious that such programs are not just a way of creating a government granted monopoly of this was the first mover to get approved, and therefore it is the only one that gets into the sandbox or gets into the pilot program. And after that, it is practically impossible for the next player to come in and really change the industry in that way. So when regulators are designing those type of programs, I think looking at, one, how open can they be? Can it be something where anyone who meets this standard is allowed into the pilot program? Does there need to be a cap because of the nature of the pilot program? And if so, really explaining why and how that cap has been developed in a way that makes innovators and the public understand that this is not just the government picking winners and losers. And then also asking, if it is successful or if it fails, what the next steps will be. So a successful pilot program might lead to deregulation or further opening up. Similarly, or it may lead to a whole new product licensure thing that can be more formalized through hard law.
So hard law and soft law are in some ways substitutes, but can also be complements. You can see soft law as a step to adapting your formal legal framework to a newer technology environment.
Certainly, and it can also be a chance to figure out what those updates might need to be and to deal with that interim where there is this uncertainty of what a future product might look like.
That's great. Well, I don't want to take much more of your time, but I am hoping that this conversation will entice people to go look up your article. And of course, we will have a link to it on the IRLE website. And I really appreciate you taking the time to talk with me today. This has been a fun discussion.
Thanks so much. And it was great talking to you as well.
Thank you.